Tonight, the beat goes to court. A special report. Russia on trial, debating the evidence of collusion. On location at the moot court in John Jay College of Criminal Justice, where former prosecutor Renato Mariotti and defense attorney Alan Dershowitz present both sides of the Trump-Russia controversy to a live mock jury. Now to tonight's host, MSNBC chief legal correspondent, Ari Melber.
Hi, I'm Ari Melbourne. Welcome to a very special edition of The Beat. We are at the moot courtroom here at John Jay College of Criminal Justice at the City University of New York. And this moot courtroom, like a real courtroom, has places for the lawyers on both sides, place for the judge, of course, a witness stand. All of this is part of what we're going to do today, which is test some of the legal arguments in the Russia probe. We even have a jury. I'll speak about that in a moment. Everything in the Russia probe under Bob Mueller up to this point has involved a grand jury, 12 to 25 people gathered in Washington making decisions about the case, but it's all secret. What's changed now with 2 indictments, 2 trials coming, maybe more, is that there will be a public jury and a public process to test some of these arguments. Now, today, we are not going to have a full trial simulation. We're not going to have a judge. We're not going to have rules of evidence or ask for a verdict to be rendered. But we are going to explore some of these key legal arguments because they will ultimately be tested, some of them, in a public court. Let me speak to our jury, which are students from this college, John Jay. All I'm going to ask you to do, like any jury would be asked, is to keep an open mind about the arguments you hear today. Now, in the public realm, there's a lot of talk about the word collusion. But what you're going to be asked to assess are 2 types of arguments. Was there a conspiracy between the Donald Trump campaign and Russia to impact the election? And if there was, did it go to the top, to the candidate? You'll notice that legal set of questions is different from the word we hear most often in public, collusion.
The entire thing has been a witch hunt, and there is no collusion between certainly myself and my campaign.
I still maintain that there is evidence of collusion.
I was there. It's a total and complete farce. Russian collusion is a farce.
Okay. There is evidence of collusion.
It's literally found 0 evidence of collusion between the Trump campaign and Russia.
The issue of collusion is still open.
I believe there was collusion.
I did not collude with Russia, nor do I know of anyone else in the campaign who did so.
Yes, there was collusion.
I am truly not involved in any form of collusion with Russia, believe me.
And now to the arguments. We have 2 of the preeminent lawyers to test out some of these ideas in the case today. Renato Mariotti is a former federal prosecutor. He's done over 100 prosecution cases, and he's currently a candidate for Attorney General in Illinois. And Alan Dershowitz is one of the most preeminent criminal defense attorneys in the country, having tried over 200 cases, and he's the author of Trumped Up: How the Criminalization of Political Differences Endangers Democracy. Each person will have 4 minutes to present their side of the case. Renato Mariotti, for the prosecution arguments, goes first.
Thank you. 1 year ago, we were attacked by the Russian government. All of us were the victims. You will hear from a representative of the Department of Homeland Security who will tell you that 21 states had their voting systems penetrated by the Russian government. You will also hear from the heads of 4 intelligence agencies, including the FBI, the CIA, and the NSA, who will tell you that they have concluded that the Russian government was mounting an influence operation to undermine our election. You will see for yourselves the messages that were paid for by the Russian government. Messages that sought to pit people in the United States against each other to weaken us. Messages where they sought to bring opposing groups together in the same spot to foment violence and conflict. Messages that sought to encourage people to secede from the United States. And messages that supported their candidate of choice, Donald Trump. You will hear from those intelligence heads that Donald Trump was the favored candidate of the Russian government. Now, ladies and gentlemen, what you may not know is that when foreign governments or foreign individuals contribute to a United States election, that is a federal crime. And it's also a federal crime when 2 people agree to commit a crime or agree to be part of a crime. That is called conspiracy. Conspiracy is just a fancy legal word for agreeing to commit a crime. Here, you will hear not only the evidence I told you about a crime being committed in the United States, the involvement of a foreign power in our election, a crime for which there can be no serious question, but you will also hear evidence that individuals, officials in the Russian campaign were involved in that effort. That evidence will prove to you that those individuals were part of an agreement to have Russian involvement in our election. And that is why the United States has charged those officials with conspiring to obtain a foreign contribution in connection with an election here in the United States. So what will that evidence be? I'd like to spend the next minute walking through that evidence with you. You will hear that the Russians had someone at the top, a man named Paul Manafort, co-chair of the campaign, who was trading influence with a Russian oligarch. You will also hear the testimony of a man named George Papadopoulos, who is cooperating with the United States. He will testify that he was receiving messages from individuals connected with the Russian government who told him that they had dirt on Hillary Clinton. And he will tell you that when he communicated that to his supervisor, Sam Clovis, another co-chair of the Trump campaign, that Mr. Clovis suggested that they send someone low-level to Russia to communicate with the Russian government. And who did they send? A man named Carter Page, who will testify that he traveled to Russia and he met and interacted with individuals in the Russian government. You will also hear that the president's son, Donald Trump Jr., met with a representative of the Russian government. She came and she offered dirt on Hillary Clinton, emails on Hillary Clinton, and you will also hear that in the same conversation, he told her that they would reconsider their sanctions against the Russian government. You will also see evidence of messages between him and WikiLeaks, which is connected with the Russian government, a foreign intelligence service. All of that evidence taken together will prove that there is a conspiracy to involve the Russian government in our election, and I will ask you at the end of this trial to return a verdict of guilty on all counts.
Welcome back to our special edition of The Beat. We are here in the moot courtroom at the John Jay College of Criminal Justice at City University in New York, and we're exploring some of the legal issues in the Russia probe. We just heard a presentation of the case against the Trump campaign from a federal prosecutor speaking to a jury we've assembled here of students. And now we turn for the rebuttal to that case. And that will be handled by Professor Alan Dershowitz, who's appealed over 200 cases and is the author of Trumped Up: How the Criminalization of Political Differences Endangers Democracy. Professor Dershowitz, you have 4 minutes.
Thank you so much. Ladies and gentlemen of the jury, I'm sure you were convinced by the brilliant argument of Mr. Mariotti that Russia tried to influence the American election. I was certainly convinced of that. The problem is that that isn't a crime. Maybe it should be, but it isn't. In 1812, the United States Supreme Court, right after the founding of our country, established a clear rule that said there must be a statute before there can be a crime. We reject the approach of countries that say you can make up crimes as you go along. The essential protection of our Constitution is statute first, crime only after the statute is clear. It is not a crime to collude with a foreign country. The United States has tried to influence many, many elections that have occurred in foreign countries. So I challenge my opponent to come up with the statute. He mentions conspiracy. Conspiracy is the broadest accordion-like crime, but you need to have an agreement to commit a crime. It's not a crime for a campaign to try to get dirt on an opponent. I'm going to make the extreme argument to you right here, and you will be surprised by this. Hypothetical case. I'm a law professor. I'm allowed to use hypothetical cases. This didn't happen. Hypothetical case. Candidate Trump calls Vladimir Putin on the phone during the election and says, Vlad, do I got a deal for you? I want to be president of the United States. You want the United States to help you get rid of some statutes that impose sanctions. Here's the deal. You help me become president of the United States, and I'll help you get the statute changed. That would be horrible. It would be awful. If it became public, nobody would vote for the candidate. It's not a crime. Collusion is not a crime. It's a crime in one context. If two businesses collude to violate the antitrust law, that's a crime. For example, if all the owners of the National Football League colluded to make sure that Kaepernick didn't get a job, that would be a crime under the antitrust law. But it's not a crime simply to collude. And it's extremely, extremely dangerous to target people because you don't like them. You know, yesterday it was Hillary Clinton. Lock her up, it's a crime, it's a crime. Emails, the deal with Russia with uranium, it's a crime, lock her up. Today it's lock him up. Tomorrow, it's you. Any of you in this jury box could be the target of a prosecutor who takes a statute like conspiracy and expands it like an accordion to get you. It was Lavrentiy Beria, the head of the Soviet KGB, who once said to Stalin, "Show me the man and I'll find you the crime." That's what's going on in this country today. It's going on by Democrats trying to target Republicans, Republicans trying to target Democrats. We have to go back to a system where we strongly oppose what may have gone on. There should be a bipartisan commission established by Congress to look into the Russian collusion. Let it all be told to the American public. But let's not invent crimes out of political sins. Our basic argument has always to be distinguishing sin from crime. Sin, the punishment comes from on top. Crime, it's we who impose the punishment for crime. This is all about the rule of law. This is not about Donald Trump. I did not vote for Donald Trump. I voted for Hillary Clinton. I'm not here to defend Donald Trump. I'm here to defend the rule of law. I'm here to defend you. I'm here to defend every American from the misuses of the criminal law. Thank you.
Welcome back to our special edition of The Beat at John Jay College of Criminal Justice, and we are back with our lawyers who've been exploring both sides of the Russia probe. We heard from legal experts and our mock jurors, our students here, about both of your arguments. Renato, starting with you, your response to the evaluation you heard.
Wow. Well, I think the first thing that I want to mention, I think the experts just talked about this a minute ago, is that while the word collusion is not anything that has a legal meaning, there are actual crimes here. So what I focused on, because of the format that we have, is conspiracy to accept a foreign contribution in connection with the United States election, which is a crime. It is a crime for someone to knowingly and willfully make a contribution if they're a foreigner, and it's also a crime to, for example, aid and abet that. Aiding and abetting is just when you know that there's criminal activity and you help to make it succeed. But there are, as one of the experts mentioned, other crimes that can be committed here. So, for example, hacking a server is a crime. I prosecuted that when I was a federal prosecutor. And anyone involved in that effort, anyone who knew that there was a hacking and helped to make that succeed, would be guilty of aiding and abetting that effort. So, for example, if you knew that there was going to be a hacking of a server and you said, "I'll help you distribute the stolen material," that would be a crime. Knowingly receiving stolen material is a crime if it's worth over $5,000.
What did you think, though, of some of the students who seemed to have questions about whether you carried the burden on this being worse than quote-unquote collusion?
Well, there's no question that I think, as one of the experts mentioned, I was hamstrung by the format. I've never tried a case before where I don't have witnesses, I don't have exhibits. Right. I have 4 minutes to make my opening statement off the cuff. So those are challenges. As you can tell, I was running out of time there at the end. So
that is what's unusual, though, again, because we're explaining how this works and what the limits are. A real prosecutor, or Bob Mueller, would have way more material than you.
Right. I mean, opening statement might last for 40 minutes, 50 minutes, an hour, and there will be weeks of testimony, hundreds of exhibits. That's what I would expect in a case like this. So, and you'd also have, as I think someone mentioned, narrow charges. You'd have charges against a specific individual, George Papadopoulos, Sam Clovis, whoever that might be, and those charges would be brought, and it would be narrowly tailored towards that specific case, as opposed to one grand case charging everyone, which is what we did here to simplify the matter.
And Professor Dershowitz, same first question for you. Your response to the evaluation of your arguments.
Well, first, one brief response. If you made it a crime to knowingly receive the product of hacked information, the New York Times would be in prison, the Washington Post would be in prison. They have all published material material, stolen material from WikiLeaks, from the Pentagon Papers. The United States Constitution distinguishes between receiving stolen goods of a physical nature and receiving First Amendment protected information. So it is not a crime to use information that you know was stolen as long as you didn't participate in the stealing or in any way help the stealing. So here we have one fundamental disagreement that I think I'm right about as a constitutional matter. In terms of the evaluation, I was very happy with the evaluation because I think it showed that my strategy seemed to have worked. My strategy was to immediately concede what I couldn't defend. I can't defend the argument, of course, that the Russians are trying to influence the election. I can't even defend necessarily the argument that there may not have been some collusion. I think
so. That's an important point. You concede what Russia was up to and that there may have been collusion, but you say you can still win.
That's right. See, I think the most important aspect of advocacy is to concede what you can't defend. You must maintain your credibility in front of the jury and then draw a line to say, look, I'm not going to argue that there wasn't Russian attempt. I might not even argue that there might not have been collusion between some people in the campaign. But show me the statute, show me the crime. And in terms of conspiracy and this campaign contribution, it can't be a crime under the Constitution to make it a campaign contribution to get information, First Amendment protected information. So I think if I were in court, even after all the evidence came in, I think I'd have a pretty good chance of winning. Also, nobody mentioned reasonable doubt. You have to acquit.
You mean you mean Jay-Z's first album?
Proof beyond reasonable
no, okay,
doubt.
I got you now.
Right.
I got confused.
Right. So I was very pleased with the evaluation. I think it was right, spot on.
And one more point on you, and then I want to go to the obstruction conversation, which we didn't focus on. Is it good for a lawyer to see what we saw, which was, I noticed some of our jurors repeating your thesis. There is a debate over whether collusion combined with conspiracy is a crime, but I heard jurors repeat the Dershowitz argument, collusion is not a crime.
What I do when I argue in front of appeal court or in front of jurors is to give them pithy, easily understood concepts that they can make their own. I try never to tell a jury in the end, this is what you should believe. I want them to come to the aha moment and have it their argument so that it's harder to talk them out of it when the jury is alone in the jury room and somebody is trying to persuade them. It's easy to talk them out of Dershowitz's argument, but it's not easy to talk them out of an argument that they have taken to themselves. That's why I try to use language like that.
And that's a big distinction, Renato, because the president continues to cast doubt on whether Russia meddled in these other issues. Now, he's speaking in public and political forums, but he's making a different argument. On obstruction, which we didn't focus on today, we can only do so much. This is not, as I've emphasized, a full mock trial. Do you think that Bob Mueller, and in this case, would have a separate grounds for criminal liability regarding obstruction of justice?
I do. I mean, this is something else that Professor Dershowitz and I disagree on. At least I believe we do, based on our prior debates. But yes, and in fact, I think there's more public evidence on that point because James Comey has already provided testimony that's in the public record that we can all view. So I'd have at least one witness, which is one more than I had this time. But look, the question is, the president certainly has the power to fire, for example, the FBI director. The question is, can he do so for an improper purpose? So, for example, could the president, in exchange for a bribe, fire the FBI director? I would say no. That even though he has the power to do it, that's a crime. And similarly,
but it's the bribe that's the crime.
Well,
it's the bribe that's the crime. And you don't have to reach the other issue. Of course, the president can't accept a bribe. But if a president did it for the wrong reason, in order to promote his own reputation, say President George Bush pardoned Caspar Weinberger on the eve of Weinberger's trial. Are we going to probe why he issued that pardon if he didn't get a bribe to do it? I think that really would endanger everybody's liberty if we could make it a crime to psychoanalyze a person's mixed motive and turn that into criminal conduct.
It's interesting because we always psychoanalyze a defendant's conduct when they are on trial.
If there's a criminal act.
If there's a criminal act.
There's no criminal act when it's a pardon.
No. Well, first of all, there's a difference between a pardon and firing the FBI director to obstruct an investigation. A pardon, by its nature, is going to derail derail a judicial process that is the point of a pardon. But if you are firing the FBI director in order to end an investigation, that is, and that is your purpose. If he said, for example, I am firing the FBI director because I want to derail an investigation,
that would not be a crime.
Okay, well, we'll agree to disagree.
Let's assume the following happened. Let's assume the president said, forget about the FBI. I am ordering the investigation to stop. I am the president, the head of the executive unitary branch. Thomas Jefferson did that. Many other presidents have done that. You don't even have to have an attorney general under our unitary executive. We have a real problem in this country. We should have a separate, independent prosecutorial branch that isn't the Justice Department. The Justice Department has two roles. One, the Minister of Justice, the advisor to the president, political role, and the other is the role to prosecute. In most other countries, those roles are separated, not in our country, and that's what causes the problem.
So, Renato, let's speak to the rebuttal of that and add the other news going on, which is Donald Trump talking openly about ordering the start of an investigation into a political opponent. Professor Dershowitz told the jury he voted for Hillary Clinton. That apparently is the person that Donald Trump wants investigated. Do you think that could be unlawful or unconstitutional? You're talking about stopping an investigation. What about starting one? And could that ultimately arise in the Mueller probe as well?
Well, let me first mention stopping an investigation because I want to respond to that point. The issue for me is not that the president did so directly, but the question is his purpose. So if he said, I don't want my son investigated because he's my son and I will not allow him to be investigated, period, I think that is a problem. Okay, if
it's a problem, is it a crime?
It's a crime if he's doing it for an improper purpose. Yes.
So let me tell you what Thomas Jefferson did. He ordered his attorney general to indict and prosecute Aaron Burr. He called the Chief Justice, John Marshall, and said, unless you get a conviction, I'm going to have you impeached. He then called in all the witnesses to the White House and said, if you testify against Burr, I'm going to give you immunity and a pardon. If you don't testify against him, we're going to go after you. That was Thomas Jefferson, the great third president of the United States. What he did was probably wrong, but it tells us what the framers of our Constitution intended the role of the president and the head of the executive branch to be.
So the rebuttal question for Renato is, does it tell us what the framers did, or does it tell us where the framers fell short? Because there are many precedents.
Both.
There are many precedents from the 1800s that don't stand up that great today.
Yeah, I mean, Thomas Jefferson owned slaves. Thomas Jefferson, as we know, had a relationship with slaves. He's done a lot of things that are improper.
But they were all legal. At the time.
I don't know if I would agree. But
you don't think owning slaves was legal?
Well, I do think owning slaves was legal, but
horribly immoral thing.
Yeah, well, that's fine. Having a relationship with a slave, I don't know if it was. But the long and short of it is Thomas Jefferson had his personal failings. The question is whether or not that is a crime or not today. I mean, Thomas Jefferson's not on the ballot and he's not alive today. A lot of things that may have been acceptable 200 years ago are not acceptable today.
But are they criminal?
I think they are. I think if the President of the United States ordered people to investigate his opponent and said, I will give you immunity if you testify against my opponent. This is the example that was just offered. And if you don't, this is going to be a problem. I'm going to go after you. Hell yes, that would be obstruction of justice.
We should.
Hell yes. Let me close.
Make that a crime.
Let me close by giving you both an opportunity. You said pithy works in court. I give you each up to 2 sentences for your final point. Professor Dershowitz.
I think the rule of law is more important than how we decide to go after particular political figures. If you don't like what Donald Trump did, and I don't like what he did in many respects, vote against him, campaign against him, go on the media against him. But don't stretch the criminal law to fit and target somebody you don't approve of. That endangers American democracy.
I think if you care about the rule of law, you should care about the President of the United States trying to initiate political investigations of his opponents and also attacking the FBI and the independent Justice Department. That is the real danger to the rule of law.
Renato, Alan, thank you both.